case. The People's State of Michigan versus Justin Phillips. Counsel, state your appearances.
Caitlin Kirby on behalf of the people.
Sorry, Your Honor. Stuart Collis on behalf of Mr. Phillips.
Mr. Phillips, please turn on your camera and state your name.
Justin Phillips, defendant.
Mr. Phillips, you're in court. Please take off your hat.
Oh, okay. Thank you.
All right, a couple of things. First of all, Mr. Phillips, once again, I have gotten right before your hearing, actually after the time that your hearing was set, I have received about 100 pages sent directly to my chambers. My chambers, Ms. Tang, has let you know that is not the way that you file pleadings in the court. And so I do not want it to happen again because I will reject it and I will not read it. I now come before the court, and I'll certainly let Mr. Collis make his own argument, but I come before the court for you now asking for a fourth attorney. And the same, and when I read over the motion from Mr. Collis, it seems we keep going through the same thing. And I'm not going to play the game. Just not going to play the game. So, Mr. Collis, I'm not saying at this point I'm going to deny your motion or anything, but what I am going to do is I'm going to adjourn this over. And with this admonition to you, Mr. Phillips, you can't keep coming before this court deciding which attorney you wish to select. So what I'm going to suggest to you is that you find a way to reconcile whatever differences you have with Mr. Collis.
Oh, no, he went
and
off.
to deal with that. No, hold it. Do not ever interrupt me, ever. That what you will do is you will attempt to reconcile whatever differences there are. If you can't, then I will deal with Mr. Collis's motion. I am not dealing with your motion. You have counsel of record. It is not going to happen this way. Mm-hmm. You are not going to make some mockery of these court proceedings. And so I'm done with you in that regard. I will adjourn this matter out to February 2nd, 2022 at 9 a.m. or as a time set by the court. Mr. Collis, use your best efforts to try to resolve this with Mr. Phillips. If you guys don't, then that's fine. So to the extent you don't like Mr. Collis, didn't like Miss Julian, didn't like Mr. Brown before then, those are the devils you know. So you can take those or you can take one you don't know. Because if I let Mr. Collis off the case and I appoint counsel, I'm not hearing another motion to withdraw. I'm done for today. We'll see you on the 2nd. Thank you, folks.
Thank you, Your Honor.
Yeah, he's assaultive. It's not good. So you can't behave like that to me.
Cut him off. Do not do that in my proceeding.
Now, court does call the case of the people versus Marissa Ians.
Thank you, Judge. Thank you for the breakout room in the last block. I did have a chance to talk to Ms. Ians. She did email me some information, which I did forward to the court and to Mr. Dowett. I know the court still has to address her bond violation, but obviously Ms. Ians is hoping the court will consider the information that I did email to the court when addressing her bond situation.
Yes, and I have reviewed the information that you forwarded to the court with reference to some of the things that may play or have some bearing. However, I still don't, based upon that, have an explanation regarding the positive or the test. Well, a couple things. Without getting into the specifics of why she wasn't testing, the very fact that she wasn't testing she certainly could have contacted community corrections to try to resolve that issue, that being an issue. There was no contact there.
Wait till he finishes, Ms. Hayes. Wait till he finishes and then you can respond.
The other thing is that there seemed to also be an issue regarding one of her testing prior to the sort of non-testing, where the person blowing into the sober link may not have been the defendant. And so you got, on first blush, you've got somebody attempting to tamper with the method of testing, as I'm looking at this, then not testing. And then once all of a sudden testing starts, I then have a positive test. And I still don't have an explanation for that, but even after having the positive test, there are certain things that defendants are instructed to do once there is a positive test, and that wasn't complied with. So to put it in succinct form, what I have is an individual that looks like they're tampered with the test, then all of a sudden isn't testing, is claiming that the reason they're not testing is because for whatever the reasons are, the machine no longer is in their possession. They get the machine back, test, get a positive test, and then don't follow the instructions that they were given. So within just that, there are numerous violations that this defendant has engaged in. So what does she want to tell me?
Well, first thing I know she wants to say, Your Honor, is that she's apologetic for the situation. She knows that she did ask Your Honor to put her on the sober link and take her off of the scram tether previously that the court did grant her. She's asking that Your Honor consider putting her back on the scram tether, and then she would not have a risk of failing any test or missing any test again. Additionally, she is working, as the court knows, as a therapist, I believe, and I believe she's on her way to work right now, Your Honor. So she is very much wanting to keep her job. She is the mother of two that she is the sole provider for. So she's hoping the court will give her another opportunity as opposed to putting her in jail. Ms. Ings, is there anything else you want to add in addition to that?
Yes, I did contact Mr. Wells at Community Corrections and asked him if I could be placed back on the tether because it was too much with that sober link. And given my domestic violence situation, and that whole week was horrific for me mentally. But I do have, with my therapist job, I have like 40 people on my caseload that are dependent on me. Like, I'll do the tether. I can do like even weekend jail or something, but I can't lose those clients and that job. And I have my kids. And it's literally only me with those.
Is she admitting to all of the violations, or is she contesting them? I'm unclear.
She is definitely admitting to the violation of the positive test on August the 15th, Your Honor. I guess she would also admit that she did not test during the weeks prior. And I believe that is what she's stating right here on the record, Your Honor, is that she acknowledges that she failed to test with the explanation that I did provide the court.
And also admitting that after the positive test, did not do the follow-up test as every 15 minutes as required.
That is correct, Your Honor. Yes.
Anything else you want to tell me?
I panicked and I have my own mental health issues. I was trying to revamp my mind and do everything with me, and with that domestic violence, like, it was terrible. Like, he took everything. So I had to revamp all my technology, all my phones, new phone numbers. Like, it was a lot. And I kind of just tapped out for a second.
Ma'am, I can appreciate that, but I can appreciate that with regard to the not testing. What I cannot get past is that you tested, you blew numbers, then you didn't even follow the instructions that are given to you for retesting on that. So we have no way of knowing. We caught you at one particular point with a 0.054, but I have no idea where your blood alcohol level was at any given point in time and whether or not you were headed up or down. And the reason I say that is because then on the next day, you just didn't test at all between the
after that, it was, I just panicked. I'm not touching that machine at all. I'm just going to wait till I go to court. And so I just stopped testing. I have the machine. It's sitting at home. I just didn't want to touch it. Like, I just wanted the alcohol tether back and just go to work and continue my day-to-day like I have been doing very fine until that situation happened.
Ma'am, you made the choice. I had you on the scram. You requested to do this. You were doing, I guess, okay on the scram. You requested that I change. I
Yeah,
changed.
and I remember that, and you said it,
Yeah.
and you said it, and that
And
was
I
my
told
mistake.
I made it very clear that you had to follow that program, and you didn't. And while I might excuse, given the report that I see, the not testing might give some excuse. The idea that what you can then do is test positive, not do the retest as instructed, and then decide at least for 2 days that I'm not doing anything. Because you're still
And
under
that
the
was my
court order.
mistake.
You can't make those decisions. So the defendant I will adjourn the probable cause conference. I'm going to adjourn it out just 1 week to the 9 a.m. I'm going to indicate that the defendant admits to the violation. Ma'am, I'm going to order that you are to report to the Washington County Jail. You are to report to the Washington County Jail by 6 p.m. today. You are to be held there pending your probable cause on the 25th. You're to be held without bond. Failure to report, I will be issuing a bench warrant for your arrest with no bond. So you can come in or we can come get you.
So
See
there's
you
no
next
way I
week.
could just
Either
at least
way.
do the weekend.
Pardon?
There's no way I could at least just do the weekends so I can
If you
save
report
my
on time,
time.
you'll be there over the weekend. Thank you.
Thank you, Judge.